Greetings to everyone. I would like to welcome you to our discussion on fundamental concepts of South African law of evidence. But first and foremost, let me thank you so much, so much for your continued loyalty and support to the channel iClass Virtual. Thank you very much for growing the channel. And I'm getting very, essential feedback from some of you, and it's quite encouraging. Remember to support the channel by subscribing and sharing with your friends. Remember to click likes if you really like what we are sharing here. In fact, I believe you do, otherwise you wouldn't be following the channel. Thank you once again. Right. So our discussion is on the fundamental concepts of the South African law of evidence. By the end of this video lecture, you would have learned quite a number of things, and this is our roadmap on the issues covered. The video covers an illustration of the distinction between substantive law and adjectival or adjective law. It defines key concepts associated with the law of evidence, outlines sources of evidence, discusses the impact of the Constitution on the law of evidence, and then it identifies various types of evidence and unveils principles determining admissibility and inadmissibility of evidence, and then it maps the scope of the criterion of relevance, what we mean by relevance. And then it demonstrates how issues, that is the critical issues to be determined in a case, get to be established. And then it goes further to identify and explain factors that affect or determine relevance. Thank you very much once more. Let's quickly go to the next item just to clarify issues as we have already outlined here on our roadmap. So a conceptual overview here, just to remind you that there's a distinction between substantive law and adjective law, and I have discussed these issues in some of the videos. Check the links there. We have a video which says how criminal and civil procedure work in courts of South Africa. Of course, here we are talking about criminal law and civil procedure, how these processes are unfold in the courts, in the South African courts. And then the other one says substantive and procedural law or adjective law in South Africa. So this one is basically an introduction. It's a conceptual outline of those issues, the distinction between substantive law and adjective law. So you must really follow up on those videos that I've whose links I've actually shared with you there. Remember, just maybe in simple terms, substantive law is that branch of law which defines legal rights and obligations and spells out the appropriate remedies for the violation of the rights. Adjective law, on the other hand, defines the processes followed in enforcing rights, and it's the science regarding the evidence that is required to enforce or defend rights, issues to do with how that evidence is gathered, how it's presented, how it's evaluated and assessed, up to the point when the court reaches its verdict. So that's the adjective law. But you notice that substantive law and adjective law complement each other. So we don't have a neat division or a clean division between them. They overlap and they dovetail in that kind of a fashion, so that to really think of one without the other is actually not even thinkable or possible. There are key concepts that require our attention Maybe the first concept that I would like us to look at is one which says, what is evidence? And to hazard an explanation, I am going to say to you that it is that branch of law which deals with what evidence is required, rather what material proof is required just to prove an issue in court. So it also deals with how the evidence is presented, what weight is assigned or attached to it, and how proof and facts are established in a court. That's the law of evidence. And what do we mean by evidence? I know people use this word loosely to say, I have evidence. Maybe they are involved in a debate or in an argument. Then they claim to have evidence, and it's a word that is used very loosely. Let's look at the technical meaning of it in law. Evidence is oral material presented before the court under oath, or it's an affirmation. So it includes documentary and real objects that are presented in court to prove a disputed fact. So take note that it is an oral material presented under oath. That's very, very important. So that's the technical meaning of the word evidence in the context of the law, but not in the context of daily parlance and daily discussion in that kind of a form. Then we want to distinguish evidence from probative material. Probative material is much broader than evidence, as you will see. So we are saying evidence, as we define it above, is not enough to establish proof, as you require other probative material that are used to establish the disputed facts. This material includes admissions, formal admissions, confessions, judicial notice, presumptions. All these are some of the evidential material or proof that is used to establish facts. If you don't understand what we mean by admissions, confessions, judicial notice, and presumptions, and statutory presumptions, you don't have to worry. We will give more time to that at the appropriate time. And just take note that admissions are made in terms of Section 115 of the Criminal Procedure Act 51 of 1977. And they constitute probative material, which means it's material that a court considers and evaluates to reach a conclusion or a decision or a verdict on the particular matter before the court. Then the plea explanation is not given under oath and is therefore not admissible. It's not admissible. It's inadmissible. What do we mean by plea explanation? When an accused is brought before court and then the prosecution outlines the case against him or her, and then she's given an opportunity to plead either guilty or not guilty, and then the court asks them to explain their plea of not guilty to clearly demonstrate what the accused means when he says pleading guilty or not guilty. And we are saying because that is not given under oath, it does not constitute part of the evidence that will later on be considered by the court in evaluating evidence and reaching a decision. Then there is a concept of proof. So when somebody is settled with the onus of proof, when somebody has to prove a certain state of affairs or fact, they use evidential material, but proof is the material presented to the court as truth. In other words, you see, proof is central to the law of evidence because it represents what has been accepted. So the parties present their evidence, and once it is accepted, once it is admitted by the court as valid to substantiate a particular proposition in respect of the claim or the argument being made, then it constitutes truth, or rather it constitutes proof. So that proof then is the validation of what has been said, accepting it as the truth. And so that's the distinction between evidence and proof. Evidence is material presented, but proof is that which is accepted as central to the truth. Then we have the term admissibility, where we are saying evidence is either admissible or inadmissible. It simply means, if we are saying evidence is admissible, we are simply saying that the court is willing to consider it. The court is willing to accept its value in proving or disproving of a certain fact. So that's what proof is. So that's what admissibility means. But we will demonstrate what we mean by admissibility later on in our discussions. So we have got sources of the law of evidence. We classify these sources as either historical sources or as knowledge sources. So you may ask yourself what we mean by historical sources. We will demonstrate the distinction between historical sources and knowledge sources in our upcoming slides. You see, still on the sources of the law of evidence, we are saying that there are historical sources and knowledge sources. In terms of the historical sources, we are referring to how the law has developed, the influences, external influences from the time when the legal system was established. What factors and developments have actually influenced the law? So in this case, we are talking about the law of evidence. You will remember that substantive law, South Africa's substantive law, actually is based on Roman Dutch principles, which were brought in by the the settlers at the Cape of Good Hope, the likes of Jan van Riebeeck, when they arrived in 1652. And so the common law principles as applied in Netherlands, in Holland rather, they became the substantive law at the Cape. But in 1795, the British annexed the Cape of Good Hope, and then they temporarily handed it back to the Boers, and they re-annexed it in 1803 and finally in 1806. So the British annexation of the Cape of Good Hope led to the displacement of Roman Dutch law principles of adjectival law with the English law in terms of the charters of justice. Of course, you find that between 1806 and 1828, the issue of which adjective law prevailed, whether it was English or it was Roman Dutch, was not clear. The matter was finally settled in 1828 when the Charter of Justice was adopted, and then a slightly different or revised one was adopted in 1834. Now, these charters were based on English law, and English court structure was adopted. English law rules of procedure and evidence replaced the Roman Dutch principles, and practitioners with an English legal background and training dominated the proceedings, and the Privy Council of the United Kingdom became the highest appellate body. In other words, all disputes in Cape of Good Hope, you know, if parties were not satisfied with the decisions of the local courts, they would appeal to the Privy Council. And so you find that when South Africa was declared a republic in 1961, the English law rules of evidence and procedure, you know, ceased to operate as directly from England. But those principles that had already been accepted and received into the South African legal system continue to prevail up to the present day. That's why you will find Section 190 of the Criminal Procedure Act still refers to the law as it was on the 30th of May 1961. There are many other you know, provisions within this act, Section 201, Section 206, you know, those actions on the compellability of witnesses and so on and so forth, they still refer back to the law as it was on the 30th of May 1961. And that is an indirect reference, therefore, to the principles of law applied in the United Kingdom, because those are the principles that prevailed until the 30th of May 1961. So the 30th of May, therefore, serves as that date in terms whereof the residual rules that still refer to the foreign law in the form of English law actually get to be rather so you find English law operated up to the 30th of May. Hence, we still refer to them in terms of the residual laws. I hope you are getting what I'm saying. So, having spoken about historical sources, we must remember that we have what are called knowledge sources. By this we mean those sources that one refers to when they have a question. For instance, if you want to know whether a particular witness is compellable or competent to present evidence, you then revisit those principles of common law based on English law rules of evidence and procedure, or you consider case law, which is judicial precedent, or you can read the Constitution of South Africa. There are sections that are specific to evidence and criminal procedure. And then you can take note of the Criminal Procedure Act 51 of 1977. And then we've got your Civil Proceedings Evidence Act 25 of 1965. And then you have your Electronic Communications and Transactions Act 25 of 2002. And we have your Law of Evidence Amendment Act 45 of 1988. So we call these knowledge sources because in order to find out what the law says, for instance, when you talk about the Law of Evidence Amendment Act, you find that it defines hearsay evidence, and then it even streamlines the circumstances under which hearsay may be admitted, that kind of a thing. So that's as far as the sources of law of evidence are concerned. But we'll give a little more attention to the Constitution of the Republic of South Africa, because it has transformed the way evidence is now being applied in South Africa as compared to how the law of evidence was perceived in the period prior to 1994. So the impact of the Constitution on the law of evidence actually is it emanates from Section 35. The Section 35 of the Constitution of the Republic of South Africa 1996 has actually had a very far-telling implication. So we are saying basically since the adoption of the Constitution in 1993 and the one in 96, the law of evidence has never been the same. For instance, let's just look at what section 35(1) says. It says, everyone who is arrested for allegedly committing an offense has a right to remain silent. You see, the issue is, in the past, accused, or rather arrested and detained persons would be interrogated, and they would be forced to make confessions and make statements that would incriminate them, and later on those statements would be used against them in a court of law. So in order to protect the accused, rather not even the accused, it may be the accused, but start off with the arrested and the detained persons, so they can remain silent. In other words, they should not be forced to make any confessions that will incriminate them. And they have a right to be informed promptly of the right to remain silent. You see, these warnings that are referred to as Miranda warnings in the United States legal parlance, it's very, very important to take note of them. So the accused, or rather the arrested person, must be informed of the right to remain silent, of the consequences of not remaining silent, and they must not be compelled to make any confessions or admissions that could be used against them in a court of law as evidence. And every accused person, now we're looking at subsection 3, because subsection 2 has nothing to do with what we are discussing now. Every accused person has a right to a fair trial, which includes the right to be presumed innocent, to remain silent, and to testify during proceedings. Right, we do have a video on presumption of silence, sorry, the presumption of innocence. If you can follow up on that one, I am sure it would help you a great deal, just to gain an understanding of what we mean by the presumption of innocence and under what circumstances that presumption operates. So in item 3I, it says every accused person has a right to adduce and challenge evidence. And J says has a right not to be compelled to give self-incriminating evidence. So these are, provisions that have very significant impact on evidence generally. Now, let's look at subsection 5, which says evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. So in other words, there is exclusion of evidence that could actually be valid and enhance the understanding of the case. But for the fact that the evidence may have been obtained in violation of the law, as a policy issue, courts do not therefore admit this kind of evidence. But of course, in thinking about the constitutional impact on the law of evidence, we must consider the limitation clause in section 36 of the Constitution, which is a limitation clause stating that all rights may be limited in terms of a law of general application. And you see, the S versus Zuma case of 1995, which was decided on the basis of the interim constitution, did it actually went very far in terms of deliberating on the impact of the limitation clause on the rights of the accused. Remember, it was an issue of an admission, and the question was whether it should be admitted, that an admission by an accused of the commission of a crime, and the question was whether such evidence was admissible in court. So the Constitutional Court then, in the Zuma case, explored comparative jurisprudence, the developments and the interpretations of the same clause and circumstances in Canadian law, in US law, because you find that South Africa's limitation clause compares very well with the Canadian jurisprudence. So for that reason, a great deal of time was devoted to analyzing Canadian jurisprudence in respect of that issue. So our next item is now to look at the types of evidence. You may wonder why there's been an inclusion of witnesses there as the type of evidence. It will become clear as we proceed with our discussion. But suffice to say that we have real evidence as some probative material that's often considered. What we mean by real evidence, we're talking about your blood samples, we're talking about your semen in the case of rape, DNA, and so on. Then we have documents, primary and secondary, serving as primary and secondary evidence. It could be records, official records, whatever document written down which purports to convey a certain message. And then we have the products of a device or apparatus. Nowadays we have a proliferation of cameras. People are actually capturing even crimes as they are developing, as they are occurring in real time. So we have questions about the admissibility and the value of some of these, this evidence that is produced by digital cameras and all kinds of recorders, voice recorders, and then we have previous consistent statements, we have similar fact evidence, we have character evidence. How far can you adjust the evidence on a person's character as a basis for pursuing whatever argument you are pursuing? Opinion evidence, hearsay evidence. Then we have informal admissions and confessions. We are going to spend more time on that later on in another video. Then we have privilege, different types of privilege, of course. Marital privilege, which excludes compellability of spouses. How about the client attorney privilege, the privilege between an accused person and their legal representative? What information can be communicated to those outside and what information cannot be? And then we have issues of circumstantial and direct evidence, and then we have the value of previous judgments or convictions. Should that evidence be presented in court to say this particular accused has had previous convictions in the past, and if so, what value would such evidence bring, and what principles must be followed in order that it's not prejudicial, and so on? Those are the issues that one has to think about. Now, let's talk about the admissibility of evidence, because that is very critical to our understanding and our application of these principles of evidence. What do we mean by admissibility? We are saying what evidence is the court willing to accept as sufficient proof, or rather tentatively, in connection with proving a disputed fact, or proving that disputed fact after all. And we are saying evidence must be relevant in order to be admissible. That is communicated in Section 2 of the Civil Proceedings Act 25 of 1965. Now, Section 210 of the Criminal Procedure Act 51 of 1977 states as follows: no evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial, and which cannot conduce to prove or disprove any point or fact at issue at criminal proceedings. Some relevant evidence may still be inadmissible if it is either prejudicial or has been obtained in violation of the Constitution or the law, Section 35 of the Constitution. Maybe let's just go back to Section 210. It says, no evidence may be accepted or admitted if it is not relevant. So the main issue there is relevant. Is the evidence relevant? Is it material to proving or disproving whatever claims are being made? So the test there is relevance. Only evidence that is relevant is admissible. Evidence that is not relevant is not admissible. And as we saw there now in terms of Section 35, subsection 5 particularly, it said that evidence obtained in violation of the law or constitution will be inadmissible, despite the fact that it may have such value in terms of resolving the case. So Lansdowne and Campbell state that if what is adduced can in law properly be put before the court, it is admissible. It is only once it has been or could be admitted that its persuasiveness alone or in conjunction with other evidence is in satisfying the court as to the facta probanda has to be considered. So in other words, only evidence that has relevance to the facts, whether you're talking about facta probanda or facta probantia, we will talk about that one a little later on. The evidence that is sought to be adduced must actually have relevance to the issues. And if it doesn't, if anything, any evidence does not have any relevance or relationship with the issues, then it cannot be presented. We are saying there are no degrees of admissibility. Evidence is either admissible or inadmissible. You can't say this one is admissible to a limited degree or to a great degree and extent. It's either admissible or it is inadmissible. And the criterion, the basic criterion I underscore is relevance. So, what do we mean by relevance? Relevance stems from a logical connection between the issues of the case before the court and the evidence sought to be adduced. It is determined by the facts in issue. So what do we mean by facts in issue? We distinguish between facta probanda and facta probantia. So we have facts in issue, which is facta probanda. Those are facts which a party must prove in order to succeed. For instance, murder is defined as the unlawful and intentional cause of the death of a human being. So the state must prove that someone was murdered and that the accused is responsible for the murder, among other issues. It must also prove that it was unlawful, it was culpable. So those are facts to be proved in order for the prosecution to succeed. And then we have facts relevant to the facts in issue. We are talking here about those facts which tend to prove or disprove the facts in issue. Now, take an example. In the case of murder, if the charge is to the effect that X murdered Y, the issues of unlawfulness and of the act and of culpability and so on must be proved by the state. But let's suppose that Y claims that on the day in question he or she had traveled overseas and she was not around, so she could not possibly have committed that murder. So she raises that alibi as a defense. So the court may then, the prosecution may then have to adduce evidence, maybe by bringing out her passport or whatever, or asking her to produce the passport which proves that she was in Canada on that day. So we are saying now the issues around having to prove whether she was actually around at the place where the murder took place or not, that is those are facts which are relevant to the facts in issue. The fact in issue is, did X kill Y? And then the facts regarding whether X happened to be at the vicinity of the scene where Y was killed. These are facts related to the facts in issue. So they are called facta probantia. They are also necessary to prove or disprove the facts in issue. So take another example. If X is accused of killing Y, and then X raises a defense that Y is alive somewhere, the question whether Y is alive and has just changed location and name and is living in another place, those are facts relevant to the facts in issue. The fact in issue is that X had killed Y, but the allegation or the claim that Y is alive is relevant to determining whether it could have been possible then for X to have killed a person who's still alive somewhere in the world. You see that kind of a distinction. I hope it is coming out clearly. So facts in issue are generally determined by substantive law, and facts relevant to the facts in issue are determined by rules of procedure, particularly the law of evidence. So remember, we spoke about X, who claims that on the day of the alleged murder, she had traveled overseas. Now, if she has to bring her passport and the record of immigration and so on, if the Department of Immigration has to be asked to confirm whether indeed she passed by the borders on the days in question, then those are matters that are being brought in for evidentiary value. So evidence is relevant either to prove or disprove a fact, and determination of evidence is a slippery slope between what is clearly relevant and what is clearly irrelevant. And issues may be reduced. So sometimes, of course, we are saying evidence is not required for every aspect of the case. Sometimes an accused may admit to certain facts. So when that happens, then you find that the issues are reduced by these admissions. So our question then is, what factors determine relevance? Relevance is determined by factors such as the importance of the issues, the potential weight of the evidence, the avoidance of a proliferation of collateral matters or issues, and the prejudicial effect that the evidence might have. And then the doctrine of precedent or stare decisis. Let's now go into detail and look at each one of them. A determination of issues of importance. How do we determine what issues are important in the determination of a case? Facts in issue are defined by substantive law. So issues can be defined in a charge sheet drawn in terms of Section 84 of the Criminal Procedure Act, or issues may be defined in terms of in the pleadings in a civil matter. So take an example of a party who alleges a breach of contract. So then the issues would have to be, raised in the pleadings, whereby the party alleging the breach would then say what the terms of the contract were and what aspects of the contract were breached, and so on and so forth. So it is the dominus litis in this case, the person drawing the summons, the litigant, defining what the issues are. And so that's the facta probanda for us. And maybe you find then the facta probanda would arise when the defendant has got to, raise defense to gainsay what the plaintiff has actually claimed in the summons or in the pleadings. So we are saying, take for instance a trial for murder defined as unlawful intentional cause of the death of another human being. The facts in issue would be an act. Did X commit any act or omission? Did X kill Y? The definitional elements, the question is it a crime? Is this conduct a crime? This doesn't arise quite often in courts, but it should be considered. Sometimes, if people are not careful, somebody may be charged on the basis of a statute that has since been repealed. And if the defense is not alert, of course we assume that the court will be competent to establish that on its own. But remember, sometimes the accused or the defense may have to say, hey, that crime with which you are charging me does not exist in the statutes. So that is in line with the principle of legality. So they are saying, is that act proscribed in terms of the common law or the statute? These are issues that must be clearly established. And then unlawfulness. X may plead private defense, that they were defending themselves. That's why they ended up killing Y. And so if that plea is made and presented, then now the onus shifts to the state to prove that no, private defense was not the issue, or it was exceeded, and so on and so forth. And then the cause of death, that is the evidential or adjective issue. A post-mortem reports proof of the death of the deceased through a death certificate. For instance, somebody may be charged with the murder of a particular person, and it turns out that the person maybe died of natural causes. So there must then be proof that indeed the death was caused by the conduct of X. So the charge sheet may contain details as to place and time, which may be an issue. Remember, we spoke about the alibi defense, where Mr. X is charged with murdering Y, but it turns out that on the day in question, the place and the time, X was lawful, was in terms of, he had traveled overseas. So it was factually impossible for X to have been in London, in the United Kingdom, and at the same time be committing a crime somewhere in Palabora, in Mpumalanga, in South Africa. Those are very important issues to consider. Facts in issue must be proved by the party who bears the onus of proof. So take note of that. It's very, very important. The potential weight of evidence. Now, remember, this is a consideration of the potential weight of the evidence in the preliminary stages of the process. The weight or the probative value of the evidence may determine its admissibility. If it is of a trifling nature, it may not necessarily have to be admitted. Facts are relevant if inferences may properly be drawn from their existence as to the existence of the fact in issue. And this was discussed and ventilated by the court in Ara versus Mpanza in 1915. That's Makepula. This, this Makepula and the story. That's Mpanza. That's John Mpanza. That was the case in 1915. Then, in order to be admissible, the evidence must allow a proper and reasonable inference to be drawn from it. That was discussed and ventilated in Mavuso in 1987. If at face value it seems inconsequential and its relevance is so problematic, then it should not be admissible. Evaluation for admissibility is a preliminary process. It's different from assessment of evidence at the end of the trial. So we must not confuse the two. There is evaluation just for the purposes of determining its admissibility. And then once it is admissible, it will then later on be assessed and evaluated at the end for the court to reach a verdict. Some of this evidence may have been admitted, but it may turn out to be insignificant. But so those are some of the issues to think about. Some evidence initially admitted may prove to have little probative value at the end. That is when all evidence is being assessed. So that's very important to think about. Sometimes, evidence is not admissible simply because the court does not want to indulge in it doesn't want to promote a proliferation of collateral issues. Collateral issues are issues by the sideline, whose relevance to the main issues remain very peripheral. So the question is, does the admission of such evidence help to resolve the issue? The court should not waste time examining all evidence which might, in the slightest degree, have some relevance to the issue. So it's only that which would be important, which would be significant in helping resolve an issue. Remote facts must be excluded, while those with sufficient relevance should be admitted. That's very, very important. So the fact that X met at Y, maybe through shooting a firearm at Y, is a very relevant issue. But what about the issue to do with the fact that some 5 days earlier, X had approached Mr. Z and asked if he could borrow Mr. Z's firearm? How important is that in solving the current scenario? Of course, it will depend on the circumstances. In some circumstances, it may be important, but you see, there must always be an avoidance of proliferation of collateral and peripheral matters, those by the sidelines. The court must actually stick with the main issues. Now, the prejudicial effect of evidence also comes into play in determining its admissibility. Remember, we read section 35.5 of the Constitution, which says evidence obtained in violation of the Constitution is inadmissible. So we're basically saying prejudicial evidence must not be admissible, despite its high probative value. If evidence is relevant to the facts in issue, but of such a nature that its admission would prejudice the accused, it should not be admissible. These are, it's about principles of justice, principles of a fair trial. Some people may argue that it is actually unreasonable to exclude evidence just because of ethical reasons and so on. But you see, there's a difference between justice as perceived by the common man and the justice as dispensed by the courts. The courts should not condone abuse of legal process. Remember, there are very dignified institutions who must always uphold principles of integrity and principles of justice, if one would say. So we are saying prejudicial evidence may render the trial unfair. That was discussed in S versus Ndlovu in 2002. So those are very important issues to always think about. The doctrine of precedent also does come into play here. Certain evidence has been ruled inadmissible in terms of previous authoritative judicial decisions. So if a certain type of evidence, like maybe the evidence that a dog can actually sniff a criminal, and that the dogs are very accurate in terms of tracking those people who have been involved in crimes and so on. That evidence, in fact, maybe you may find that a dog, such a trained dog, may be used to track somebody. And then, but now for the court to convict somebody on the basis of the sniffing powers of a dog, it can actually create very, delicate questions about how, valid and how reliable such dog sniffings are. So in terms of judicial precedent, in 1920, in the case of Truppetto, for instance, the court could not accept the evidence of a sniffing dog. And that matter was confirmed in S versus Shabalala in 1986, that honestly, the sniffing powers of a dog may not be sufficient to found a conviction in a competent court of law. So precedent in that case then played a significant role in determining what must be admissible and what should not be admissible. Thank you very much once more for taking your time to be part of this discussion. This lecture has explored preliminary issues regarding the law of evidence, including historical and knowledge sources. It unveiled the main conceptual matters around the law of evidence. Admissibility of evidence and relevance of evidence were discussed in detail, and the lecture introduced various types of evidence presented to prove disputed facts. And the next video that we are going to do, that you will have to watch, it explores the various forms of evidence in respect of relevance, admissibility, scope, and the limitations. And what are those types of evidence that we explore in the other video? It's hearsay evidence, previous consistent statements, similar facts evidence, character evidence, opinion evidence, informal admissions and confessions, and real evidence, which are discussed elsewhere. The subject of privilege and other forms of evidence also gets to be discussed in another video, as do the issues of the presentation of evidence, all the stages in the trial process, up to issues to do with the assessment, evaluation of evidence, and then the reaching of a competent verdict, and so on. So look out for all those other videos on compellability and competence and compellability of witnesses. These are the many other issues that are ventilated in the other videos. So do yourself a favor by looking out for those videos. Once again, my name is Philani L Ndlovu. Thank you very much for being part of this. Again, I remind you to click your like, to subscribe, and to share with your friends. Let's keep this community growing. Thank you very much. Enjoy the rest of your day.